Several people have posed this super inside baseball geeky question about whether or not seeking nominal damages in Second Amendment cases could potentially help make sure that anti-gun jurisdictions such as New York City, New York State, and the like cannot get out from under a final adjudication on the merits of a Second Amendment claim simply by mooting out the law, by enacting some law that eliminates the gun control law temporarily, allowing a court to dismiss it out of hand as moot, and thus we never get a favorable Second Amendment ruling, which we've seen in the past. Well, I want to talk about, can claims of nominal damages solve this problem of mootness that we sometimes see in Second Amendment litigations? Stay tuned if you really want to get geeky on the Second Amendment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and a nominee for 2 separate categories in the 2024 Gundy Awards, Top Male Influencer, and Top Voice of the Second Amendment. I am honored to be nominated in both categories. All right, folks, so here's the story. You may recall before the NYSRPA versus Bruin case was decided in 2022, there was another case involving New York City law and carrying pistols. Specifically, that case was NYSRPA versus the City of New York. And that case was a Second Amendment case that was granted cert. And the question really was whether or not the City of New York violated the Second Amendment by virtue of very restrictive rules about whether or not people who had gun licenses in New York City, could they bring their gun under the Second Amendment to gun ranges for training outside of the city, or were they required to only go to those very select training centers, gun ranges, within the City of New York? Well, when the Supreme Court granted cert in this case, immediately what happened was, and this was, I believe, in 2019, the City of New York and the State of New York freaked out and were very concerned that this was going to be a very favorable Second Amendment ruling, so they immediately went to town trying to moot the case out. Now, as a quick reminder, under the United States Constitution, federal courts have jurisdiction pursuant to Article 3. Article 1 deals with Congress. Article 2 of the Constitution deals with the presidency. Article 3 deals with the judiciary. It specifically says that federal courts could only have jurisdiction over what are known as cases or controversies, which means actual live disputes. They can't adjudicate, let's say, who is the best baseball team in the world or anything like that. They only can adjudicate legitimate actual fights that are going on in the court system. So in NYSRPA versus City of New York, the city and the state began to coordinate together to try to moot out this case. One of the things they did immediately was New York City changed the law quickly, which was very easy to do through the city council. Even though they had been arguing this is a critical matter of public safety to save lives, the entire way up the court system, they had won in the trial court at the district court, they had won in the U.S. Court of Appeals for the Second Circuit, because this is supposedly, this carry restriction on where you could train was mission critical and would save lives. That was the position. But as soon as the Supreme Court granted cert, they immediately changed the law. Not only did they change the law at the city level, they changed it at the state level to make sure there was no debate whatsoever that this law that was being challenged in the U.S. Supreme Court was moot. And indeed what happened after this is the U.S. Supreme Court did conclude that the case had been mooted out and never issued a Second Amendment decision on the merits. Instead, the court issued a ruling saying that the case was moot and they wouldn't decide the Second Amendment question presented because it was a moot point. It was no longer a live case or controversy. So in light of this and all the fights that have been going on, there's been a lot of discussion, for example, on X about how do we deal with future situations where, guess what? The anti-gun community might try to moot out cases if a Second Amendment case gets back up to the U.S. Supreme Court by changing the law. And one of the ways that some people have suggested trying to eliminate the mootness requirement is if you, as a Second Amendment plaintiff, sue not just for injunctive relief to declare the law illegal or unconstitutional and to enjoin it forever, but also to seek what's known as nominal damages. Now, damages is when you ask for money from the other side. Usually in damages cases, people ask for money and say, hey, you stubbed my toe, you hurt my leg, I want to be recompensed for that injury, pay me the money. Or you breached your contract, pay me the money to make me whole. Those are real damages. But there's something known as nominal damages. Nominal damages are usually a small token just to indicate that you won the lawsuit, somebody else lost the lawsuit, and they have to pay you $100 or $50 or something like that, something nominal, just enough to show that you won the case. The question is, if people sue for injunctive relief under the Second Amendment and for nominal damages under the Second Amendment, and then what happens, of course, is if the anti-gun communities decide to change the law to moot out the case on the basis of injunctive relief, can you still get a Second Amendment ruling because you're asking for nominal damages and you've been injured at least during the duration when that illegal unconstitutional law was on the books? Well, there's really three ways to consider nominal damages, and I think this is a creative way to think about it, but I think it's a little tricky. So the way to think about it is, who exactly are the government actors being sued when you bring a Second Amendment case? And again, most of the time, to be clear, when Second Amendment organizations bring Second Amendment cases, they seek two things. They seek to have a declaration that the law is unconstitutional under the Second Amendment, and then they seek to have it permanently enjoined so it can no longer be enforced. And then relatedly, they ask for attorney's fees under a civil rights law, Title 42, USC, 1988, to get reasonable attorney's fees and costs back for the cost of bringing the lawsuit. That is what most, 99% of the lawsuits involving the Second Amendment look like. So the question is, can you now add an additional claim for beyond the permanent injunction of the Second Amendment violative law, that gun control law that violated the Second Amendment? Can you get nominal damages, and should you ask for them? Well, again, let's talk about who are the general defendants that usually get involved with these cases. Well, the first one, I think, is the cleanest and maybe the best argument for having nominal damages in addition to injunctive relief as part of what you're trying to get in a lawsuit. That is, if you're suing a local government, a town's council, a city council. The reason why nominal damages might make the most sense there is because the more the level you get to, the easier it is for them to change the law. So if you have a city council of 5 members and they go to the U.S. Supreme Court and now they fear losing, they can quickly change the law because they only have to change the minds of 5 people, 3 out of the 5, let's say. So, of course, in that situation, you really do perhaps want to ask for nominal damages because it's so easy for them to moot out a case by changing the law. It's much harder, for example, to change a federal law, an ATF law, or a state law. A lot more moving parts there. But at the local level, usually not that hard. So in that situation, if you're suing a city or a town or a village, they usually don't have what's known as sovereign immunity. Now, we'll talk more about sovereign immunity in 1 second, but basically the doctrine of sovereign immunity says that you cannot sue the king, you cannot sue government unless the king or government gives you consent to sue them. And that is the general rule across the United States, sovereign immunity. The government cannot be sued unless they grant you permission to do so. And at the local level, the doctrine of sovereign immunity is usually not very strong. Sometimes you don't even have the doctrine of sovereign immunity applicable to a local village or county situation. So that's very favorable, and that increases the odds that you may want to seek nominal damages. Moreover, you can sue them under the classic civil rights laws of 42 U.S.C. 1983 for violation of the Second Amendment. So again, you have very strong civil rights claims against local laws, and you can ask for nominal damages because you don't have to deal with the doctrine of sovereign immunity. And you'll see why that's very important in a second, because by asserting nominal damages, you have to get around sovereign immunity, and that can be sometimes very expensive and hard to do. But if you're suing a local government, it's a lot easier. So if you're going to sue a local government, a city, village, town, county, then yeah, I think there's a very strong argument you should consider adding a nominal damages claim in addition to your injunctive relief claim in that context. But let's now move on to a more complex situation where the state, for example, the state of New York, the state of California, is violating the Second Amendment rights. Let's play that out, whether or not you should assert nominal damages in those cases. Now, at the state level, it's, again, more complicated because the states, generally speaking, do have sovereign immunity protections. So, as a general matter, You can sue in federal court a state for injunctive relief, but you can't sue the state itself for monetary damages. This is part of the 11th Amendment and the like, for example. But the bottom line is that it's well established that if you're suing in federal court, a federal court as a general matter cannot award damages to you from the state. They can award attorney's fees, but they can't award damages. There are very, very few exceptions to this, and the biggest exception to this is you might not be able to sue for damages the state of California or the state of New York, but you are allowed to sue in their personal capacity government employees. So, for example, if you want to sue a police officer in his individual capacity because the police officer violated your rights, you can not sue the state for damages, but you can sue that particular police officer for damages personally out of his wallet, out of his pocketbook, if you will. But that still is difficult because in order to sue a police officer or another government official, like a town clerk or whatever it is, you have to sue them personally, and to sue them personally requires you to get around a doctrine known as qualified immunity. Now, qualified immunity really makes it very difficult to show that an individual has violated your constitutional rights, because you really have to show they really knew what they were doing, they really violated it, and they knew they were violating it, and they did it anyway, and it's really bad. And again, the problem is that it's very easy for a court to use qualified immunity to say, well, yeah, it looks like the police officer or this town or this state agent did something wrong, but it was kind of gray, a little fuzzy what the law really was. They might not have really understood the law. It was a little fuzzy as to how it applied here. So I'm going to dismiss the Second Amendment nominal damages claim on the grounds that you don't satisfy the procedural standard of qualified immunity. So at the end of the day, I'm not sure suing a state official in their personal capacity for a violation of the Constitution is going to get you very far. The juice is probably not going to be worth the squeeze, as they say, in that context. So nominal damages, seeking that against the state or against state actors in their personal capacity, is a heavy lift. And generally speaking, I would say it's probably not worth doing if you're suing the state of California and individuals in the state of California in their personal capacity or whatever, official capacity. Probably you're better off seeking just injunctive relief and attorney's fees under 42 U.S.C. 1988, because the reality is it's going to be hard to get around that qualified immunity, and a court that hates what you're doing and doesn't like the Second Amendment is probably going to be able to use the doctrine of qualified immunity, which makes it very difficult to sue government employees in their personal capacity. They're going to probably use that as a weapon to shut down your case and knock you out. So the money you spend on it is probably going to go to waste. So as a general matter, I would not encourage nominal damages if you're suing a state, or even if you're suing state actors in their personal capacity. That's my general observation about the situation. Okay, the last thing is the hardest and probably the least likely situation where you would want to seek nominal damages, because it's not going to succeed, is if you're suing for a Second Amendment claim against the federal government. To begin with, the federal government clearly has what's known as sovereign immunity. So you're not going to be able to get money out of the federal government for a Second Amendment claim as a general matter. It's just not going to work. So you're just going to want to get injunctive relief. There is a way around this by asking for damages, which is known as a Bivens claim, B-I-V-E-N-S, a Bivens claim. But these really only are claims where you can sue a federal government employee for something they've done that's clearly unconstitutional. But there's two things to keep in mind about Bivens claims in the 21st century. The first is they really only apply to federal law enforcement, like FBI agents, number one, and it has not really been expanded beyond that by the U.S. Supreme Court in decades. So the odds of you being able to get a Second Amendment nominal damages claim under the Bivens doctrine is highly unlikely, because again, it's a very hard, set of criteria you have to satisfy to show that the federal government, the individual federal government employees knew what the law was, they knew what they were doing violating your constitutional rights, and they did it knowingly in any way. And given the fact that a lot of these blue state courts are going to say that the Second Amendment jurisprudence is in flux, there's a lot of debate about it, there's some confusion about it, it makes sense that a federal law enforcement officer or federal employee would not know the true confines of the scope of the Second Amendment, given it's a developing area of law. I think it'd be very difficult to establish what you need for a Bivens case, which is, again, that the police officer or the federal officer knew what the law was. They knew the constitutional rights. They knew they were violating your constitutional right. It was crystal clear, and they did it anyway, and it caused you damages of some sort. It's going to be very difficult to do in the Second Amendment context, is my guess, unfortunately, right now. So if you're suing the federal government, I would say seeking any kind of damages, nominal or otherwise, is probably a waste of time, because in addition to the fact you can't sue the federal government itself because of the doctrine of sovereign immunity, you can't really use Section 1983 claims because it doesn't really apply to the federal government. And last but not least, if you try to name an individual personal employee of the federal government, you got to use the Bivens standard. And again, that's extremely high standard to satisfy. And it's highly unlikely you're going to be able to pull it off in the context of a developing area of law like the Second Amendment. So, all right, well, again, these are just some general impressions for practitioners out there to keep in mind. If you guys want more information and feel like they've got to get into more detail, let me know. But as a general matter, I think this is a good overview of whether or not to seek nominal damages to prevent Second Amendment claims from getting mooted out by a change in the law after the lawsuit or after the case is going before the U.S. Supreme Court. Just again, some food for thought for all you to think about out there in the Second Amendment community. Okay, hope you learned something today. Here at the Four Boxes Diner, please follow me on X at Four Boxes Diner. And again, feel free to share this video and like and subscribe. Many people say they've been subscribed and then they are unsubscribed. So make sure you're subscribed and double check. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.